following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penney, attorney at law. And now, RadioLawTalk.com.
Welcome to Radio Law Talk. Todd, Denise, and I have been sitting here. The caffeine's starting to wear off. We're going to re-energize with more caffeine. If you want to join us, call us at 855-LAW-RADIO. This is by far the most exciting, entertaining, and sometimes informative show on Earth, other than the alien shows, which by far are the most informative shows on Earth. Remember, we're talking about general topics of law. Seek counsel for any legal issues you have. Do not go and use what we say as legal advice unless you're at the dinner table at Thanksgiving, Christmas, Hanukkah with your in-laws and you want to one-up them when they say the famous, they say, you just say, no, Radio Law Talk says as follows, and that's what you can do. And we've got a lot to talk about. We're going to do case or no case. We're going to talk about, just very briefly, the Supreme Court. Trump asked the Supreme Court to shield his tax records. And we're going to talk about a high school baseball coach that has a 7-year legal battle. And not only that, after the 7-year legal battle, he wins the case. We're going to tell you what he wins about. Todd wants to talk about Woody Allen, and you and Denise, you want to talk about United Airlines pilot issue. We'll talk about that if we can get to it. This third hour is interesting because we do a thing called Quick Takes at the very end. We're going to do a quick take where we say a quick thing, just a jab at some of the topics we've talked about today. But there's really quick, Denise, we were going to talk about Roger Stone. It just came down that Roger Stone, who is an advisor to the President Trump, has just been found guilty as of Friday, I believe, in his in the case where he's being charged with, what was he being charged with?
I think Denise has this one.
Lying to Congress, witness tampering, obstructing a congressional committee's proceedings. And there were 7 counts, and he was found guilty on all 7 counts.
That was Friday.
And what's so strange about this is everybody thought this was going to take weeks and weeks and weeks. And relatively, it happened like within a week.
Okay.
Very, very crazy. But he doesn't get sentenced until February.
Okay.
So we'll know more about that in February.
And this is the one we talked about last week where the judge said you couldn't have any stop the references or don't go home and watch The Godfather.
Oh, yeah.
Right.
That's right. The one we talked about last week. So interesting stuff here.
Good appealable issues, I think. Trump is asking the Supreme Court to shield his tax returns from prosecutors, and this is a big issue about separation of powers, Todd, and you've kind of followed up on this a little bit.
That's right. So President Trump, well, are we doing a case or no case?
No, I want to talk about this first.
So I just want to differentiate this from a lot of stuff that's going on right now. There's a request from one of the committees in Congress. We just had it there, Denise. It was anyway.
It was the one that enforces.
Yes. Not Ways. Anyway, so there was a request, and what spurred this was back when Michael Cohen was testifying before Congress, he made an allegation that President Trump, Donald Trump, before he was president, would inflate his net worth in order to qualify for loans.
This is the Manhattan District Attorney's office.
And he went further than that. He also said that Trump would deflate his net worth when it came to his tax returns.
So what happened was, he did that, and there was a question, but it all arose out of Michael Cohen's testimony before Congress. And so, in order to follow up on the validity of Michael Cohen's claims, because obviously his credibility was called into question based upon numerous misstatements, Congress decided to, or this subcommittee decided to go ahead and subpoena his tax returns to see, okay, what did he say? What was his net worth at various times? And the Trump administration has been fighting it. It was the House Oversight Committee was the committee that was seeking it.
Got it.
And what happened recently was a federal panel said, okay, yeah, you have to turn it over. Mm-hmm. And since then, and this was just a couple days ago, since then, the attorneys for President Trump have appealed it to the Supreme Court, yet to see whether the Supreme Court's going to grant certiorari to take up the case to actually hear it. But they are seeking relief or petitioning the Supreme Court to overturn that decision on whether or not the tax returns need to be turned over. So everything is in limbo. When you file an appeal, everything is like pressing the pause button to see what the appeals court is going to do, and that's where we are. So that's why they want it, to see if Cohen was lying or not. The Oversight Committee is the one that wanted it, and that's the status. We'll see what happens going forward.
I don't think it's just to see if Cohen's lying, but I do think it's to see whether or not
It was his testimony that precipitated the request.
That's exactly right.
But that's not the real reason they want it.
And it was part of Mueller, but Mueller then gave it away, pushed it toward the committee, I think.
Well, no, remember that when Mueller would come across something against somebody that wasn't directly related to his investigation, he would refer it to the specific district of U.S. Attorney's Office to prosecute. That's what happened with Cohen. Then, as a result,
and Roger Stone too.
And Stone, but as a result of that, then it ended up going before the House committee for further testimony.
So you know what this all means? Don't work for a politician.
That's right.
Don't go in and get into politics. Not that you're dishonest, but man alive, no matter what you do, the other side's going to come against you. If you're a Republican, the Democrats are going to come against you no matter what. Right. And you're a Republican, and if you're a Democrat, the Republicans are coming against you. It just seems crazy.
Tell you what, Papadopoulos would sure say that.
Exactly
I'm saying all the people around the politician are going down, and that's very... yeah.
Well, somebody wants to shake up this, whatever is perceived as the status quo. The people who would be shaken up are saying, wait a minute, we'll get you.
Yeah.
Yeah, that's what it seems like. Yeah.
This country's interesting. Though I always say it's the best there is out there. It's got a lot of flaws. But this is the most interesting one about this. Jury clears a high school baseball coach 7-year legal battle. The baseball coach tells this kid to slide into third base. Right, it was third base.
That's right.
And he has a serious injury, and this poor kid, and I feel bad for the kid, has a serious spine injury, and for 7 years this legal battle is brewing. And now I know we're turning a lot over to Todd, but Todd's baseball. He follows baseball. Todd is actually an announcer for baseball, and he likes to follow anything and everything to do with baseball.
That's right.
So what happened here on this one?
So you look at this case, and here's the setup for the game. It's the second inning. The plaintiff, the kid and his coach, their team was up 6-0.
How old were they, by the way?
This is they were freshman, sophomore year in high school.
Yeah.
Okay.
Junior varsity.
Varsity team, and so the plaintiff, he took his at-bat. When he was at-bat, there was runners in second and third. He gets a great hit. It knocks in the runners from second and third. The hit goes to the outfield. He gets a double easily. He rounds second. He's going to try to stretch this to a triple. The coach in question is the third base coach. And as he's coming into third base, the coach thinks this is going to be a bang-bang play, meaning the ball from the outfielder is going to be thrown. It's going to get to the third baseman about the same time the runner does, and he says, slide. So he tells the kid
Stop
to come
right there. Show your hands.
I'm giving the universal slide as if, you know.
They do that, don't they?
Yes.
They don't say it.
So he says, get down and slide. The kid goes to slide in and suffers a major ankle injury that at one point in time doctors thought they might have to amputate. It was that horrific. But it was a freak injury, and the kid's parents decide to sue the baseball coach for the injury that happened during the course of the game. When we come back from the break, we're going to talk about what was decided by the jury and some of the legal wranglings that occurred coming up to that point about what standard was going to be used.
Yeah, that's interesting, the standard. But that also the school district, weren't they sued also?
Everybody was sued that the folks thought they could.
We're going to be back to talk more about this baseball case, and then we're going to talk about Woody Allen.
Hey, call us at 855-529-7234. That's Law Radio.
We'll be right back.
All advertising for legal services on Radio Law Talk is strictly for the state or states in which the advertiser is licensed. For more information, go to radiolawtalk.com.
Warning, don't let your business get left behind in what is likely to be the biggest economic boom in recent history. If you need to build for your business to grow, call General Steel today for a pre-engineered steel building designed for your needs. No wasted space. Steel prices are expected to rise, but you can still lock in your price on a General Steel building. And you can still save as much as half the cost and time of conventional construction. As much as half. But you must call now. If you need a church building, office, warehouse, manufacturing space, retail space, or more, call General Steel today. You can still get the General's 50-year structural warranty and General Steel quality, all at a price you can afford. So don't let rising steel prices put your project out of reach and stop you from making your company great.
800-617-9312. 800-617-9312. 800-617-9312. That's 800-617-9312.
Hi, my name is Lily. My mom and dad used to fight about money all the time. Then one day, I heard them talking about this guy, some uncle I never knew, called Uncle Sam. Well, they say this Uncle Sam guy wanted them to pay him like $1 gazillion, and they didn't have $1 gazillion. So they called this company they heard on the radio called the Tax Doctor. And the Tax Doctor worked with Uncle Sam's people. I think they're called the IRS. And they were able to work it out so my mom and dad didn't have to pay Uncle Sam very much money at all. So now mom and dad are happy, and I'm happy too. Thanks, Tax Doctor.
If you owe $10,000 or more to the IRS or state, call now and pay less. 800-263-2610. 800-263-2610. That's 800-263-2610.
Life is full of bittersweet transitions. It's difficult to know how these changes will impact us over time. For some people, difficult transitions like retirement, divorce, or loss of a loved one can hit harder than expected and may contribute to feelings of hopelessness or even thoughts of suicide. The risk of suicide is even higher for men over 50 who served our country. Guys like me. That's why support from friends and family makes such a big difference. Every day, your actions could help save a life. Together, we got this. Learn how you can help save a life at veteranscrisisline.net.
Even in the hustle and noise of this modern world, we feel the pull of the forest, to walk under the canopy and feel transformed. National forests are essential to life. Majestic and grand, they clean our air, supply drinking water to millions, and provide homes to countless wildlife. They fuel our imaginations, inspiring us to think big, and now's the time to do just that. Fires and natural disasters devastate our forests each year. That's why we're replanting millions of new trees across the country. The Arbor Day Foundation needs your help. We've heard the call of the wild, and we've answered. Scientists, foresters, volunteers, and members, together we can preserve and protect our heritage and legacy. We must act now so that the generations of today and tomorrow can continue to depend on our forests. Visit arborday.org. See how you can help.
I like the Amargosa Valley.
Radio Law Talk. Now back to the show.
So Woody Allen spotted cruising in New York, cruising around in New York with his wife for the first time since the settlement of a lawsuit. We're going to talk about that, but before we get to that, we're going to also talk about this high school baseball coach that we didn't finish on, about this 7-year lawsuit that left a young man critically injured. So there's no winners here no matter what I say, but go ahead, Todd. What was the issue there?
Yeah, well, why did it take 7 years? That seems like a long time. And the reason why is there was a dismissal, an appeal, and a reinstatement that occurred in the case, and that just takes a while to litigate all of that. When the plaintiffs sued, they alleged in their complaint that the high school coach was negligent and careless. That was the basis of the lawsuit. It was a negligence lawsuit. The defendants, the high school coach and the school board, said, you know what, that's not the right standard. You guys needed to allege recklessness, not negligence, recklessness, based upon a case in New Jersey that said that was the case. They filed for summary judgment after discovery, and the trial judge, the judge to which it was assigned, agreed with the defense, said, yeah, recklessness is the appropriate standard. You should have alleged that. You didn't. I'm dismissing the case. The appeals court agrees essentially with everything the trial court did up to that point, but up to the point prior to dismissal, but said, no, you should have, based upon the facts that were there, first, you should have reviewed to see if, notwithstanding the fact that it wasn't alleged in the complaint, if the recklessness standard was still met by the facts that came forward in discovery.
Oh, in the summary judgment.
Yes.
Okay.
Because in New Jersey, they have very liberal pleading requirements. And so even though it's not listed in the complaint in New Jersey, if a cause of action is suggested by the nature of the evidence, that can be used to defeat a summary judgment motion, and the judge didn't do any inquiry as far as that's concerned. And so the Supreme Court, or the appeals court for this, and it was the New Jersey Appeals Department of that specific court, said, no, this has got to go back to the trial judge to review to see if there's enough facts that were alleged to satisfy the recklessness allegation, even though it wasn't alleged. And apparently, after reviewing it, the judge said, yep, there is enough here to determine that that the recklessness standard should apply, and that there's enough facts to show that it should defeat summary judgment. So it ended up going to trial, and as a result of the trial, the jury found, yeah, recklessness was the correct standard, and no, plaintiff, you didn't meet it. There is nothing to suggest that the coach's conduct in this case of telling a person to slide into third when the ball is coming, which is a play that happens all the time in baseball, there is nothing to suggest that the coach was reckless or intentionally causing that, and that's why the plaintiff lost, but it took 7 years to get there.
Here's the issue that's really about this case, and the question is, and it's not just about whether they win or lose this case, is there more lawsuits coming against schools, and schools are going to protect themselves and therefore start eliminating sports, or at least eliminating the sports that aren't quite as, I'm going to say, popular, the peripheral sports, for liability. Do they start dumping them? Don't forget, this was, by the way, it was a 7-1 vote, the jury, that said that the defense, the coach wins, and so does the school.
I think coaches are going to have insurance.
Well, they should through the school.
They do.
No, I think they're going to have their own insurance as well.
When I coached, I had to buy my own. I had to buy my own insurance, my liability insurance.
I'm just curious that if I'm the defense, I want to ask the plaintiff, okay, on a play like that, when the guy is coming around and the ball's coming in, what should the coach have done? If the coach shouldn't have told him to slide, what should the coach have done at that point? Just tell him to stand up in there?
Duck.
I don't know, the duck would.
He could have got hit in the head.
That's what I'm thinking.
What was he supposed to do? The reason you slide is because in the rules of baseball, if your momentum takes you past the bag on any play other than a single down the first base line, if you're not on the bag, you get tagged, you're out. You slide so that you can stop on the bag.
Yeah,
what was he supposed to do?
Grab it with your hand.
Yeah,
but it still requires the action of going down. And the other point is that coaches, when they put that universal motion that Todd did, they'll stand there and they'll show a side to which they want you to slide. They'll say slide inside the bag, slide outside the bag. If they don't want you to slide, they'll just hold up their hands.
But when I slide, usually, Cal, to the bag, there's usually it's like a dust storm.
When I did it, they put a seismometer back at the catcher.
And look,
I'd say a dust tornado.
There's a technique for sliding that they teach where your feet are up. And what happened was when this kid went in to slide, his cleat got caught on the ground. And,
it broke his ankle.
Physics just says that the laws of motion and mass, if your cleat gets stuck and you got a weaker joint in the ankle, it's going to have so many pounds and it's going to hurt. It's going to break. But it's not carelessness or recklessness on the part of the judge
or on the part of the coach. They now use breakaway bags.
Yeah.
So when you come into the bag is mounted on this little kind of a suction cup system, and you hit and the bag pops off. Still possibility of injury, but that's what they use now for safety.
Yeah.
Other things
so
like that.
So that's the long and short of it. The coach was, but I agree with you, Fred. There's only going to be an increase in lawsuits against schools. I think that it's going to cause eventually schools. I see a bunch of schools saying, well, we can't afford to run this sport given the liability that's associated with it. And even if we try to get waivers, it's difficult to get waivers from minors. You got to get them from their parents. If the kid just signs it, waivers by juveniles don't really count.
That's funny that you would say that. That came up recently for me when we had a child that both parents were not involved in the child's life, and the school was not allowing the child to be in sports without both parents signing on and doing waivers for that child. And that can be problematic too, having both parents involved in the child's sport.
And it's not when anytime you require parental waivers, I've even seen religious organizations where they won't allow a juvenile to join unless both parents agree. And so it's difficult, but yeah, Fred, if this continues, high school sports going to take a hit.
We'll be back, talk more about Woody Allen.
Thanks for listening to Radio Law Talk. There's more coming up.
Hi, I'm Johnny Urson-Tata. After living with quadriplegia for decades, never did I imagine I would also have to battle breast cancer. For me, the diagnosis of stage 3 breast cancer came after identifying a lump that hadn't been there before. It was out of the ordinary, and all kinds of thoughts crossed my mind, like, how will they perform a mammogram when I'm in a wheelchair? Plus, I worried about how cancer would affect my husband and caregivers. But friend, if you have a disability like me, it's important that you not let these concerns deter you from being evaluated by a medical professional. Speak with your doctor about the importance of mammograms and self-exams, and then visit disabilitycampaign.org to download free resources on breast cancer prevention tips, including how to prepare for a mammogram when you have a disability. Again, that's disabilitycampaign.org.
All advertising for legal services on Radio Law Talk is strictly for the state or states in which the advertiser is licensed. For more information, go to radiolawtalk.com.
Not all law firms have extensive experience in all areas of the law. It's wise to look for firms that have knowledge and understanding in your particular area of concern. So go to prolawfirms.com. They have listings of attorneys in key areas of practice, such as family law, estate planning, personal injury, bankruptcy, and so forth. When you're looking for a lawyer that has extensive experience in your particular area of need, go to prolawfirms.com. That's prolawfirms.com.
ProLawFirms.com is not a law firm and does not endorse or recommend any specific law firm.
If you're one of those independent people who wants your own business and you love food service, we just might have a great opportunity for you. Iceberg Drive-Ins. Iceberg is famous for its thick shakes and delicious food. We lend you our supply chain and expertise, and you can potentially have a thriving, successful, fun business that your customers will love. Iceberg Drive-Ins has some prime areas available right now, so if you're interested, get in touch with us right away. Go to icebergdrivein.com and click on the Contact Us button. Iceberg Drive-In, ready to grow with you.
Know someone with a drinking or drug problem? Learn how to get sober after we share these stories.
I was 35 with 2 beautiful children when my life and addiction started to spiral out of control. After my divorce, I went into a depression cycle and started drinking more often and using prescription drugs. After my second DWI and arrest, my ex-husband threatened to take our children away from me.
I was 17 when I became addicted to heroin and meth. I thought I could quit on my own, but I couldn't. It hit me when I was arrested.
Get sober now. Your private insurance may cover costs and we'll get you here. It's simple. Just call Elite Rehab Placement right now. Please, don't wait. Your life matters to us. 800-918-1376. 800-918-1376. 800-918-1376. That's 800-918-1376.
I am Cameron Levitt, Chief Operating Officer of Concussion Medical Clinic. California's first concussion medical clinic is now open. As concussions increase each year, there has never been a greater need for concussion specialists. Our physicians at Concussion Medical Clinic are board certified in pediatric neurology and sports medicine and have partnered with universities, hospitals, and rehab clinics to expedite the recovery process. Simply put, we are elevating the standard of care. When you need an expert concussion opinion or concussion care, visit concussionmedicalclinic.com to schedule your appointment.
I've got to get my car washed. This dirt, it just won't do. But I don't have no time today. I don't know what I do.
Man, I know this place right down the road. Quick Quack Car Wash. Hop inside, let's take a ride and watch this cat and shine. Just come and see, I guarantee your ride will steal the show. Come on, Quick Quack Car Wash. Don't drive that dirty car. Quick Quack Car Wash. They'll have you looking sharp. Come on.
Fancy pants peanut butter? A big screen television? You haven't even bought a sofa yet. A motorcycle? When your father finds out, he's gonna flip his shoes with 2 buckles? What do you even need 2 buckles for? Mr. Big Shot, buying whiskey shots for everybody in the bar. From the looks of it, I'd say nobody even remembers. Feed the pig.
Infectious diseases spread by pests like malaria, Zika, and Chagas disease are causing a worldwide health crisis. Fortunately, here at home, we don't face the same level of threat, but we shouldn't let our guard down. Mosquito-borne diseases like West Nile virus and Zika are impacting communities across the U.S., and Lyme disease spread by ticks is on the rise. Whether around the world or just around the block, get the facts you need to protect your family at pestworld.org. A public service message from the National Pest Management Association.
Is this real life? Oh, stop it. Oh, come on.
Radio Law Talk. Now, back to the show.
I agree with all that. We're going to finish really quick on, we're just throwing things a little bit different. Woody Allen, and then we're going to go into our case or no case, our third hour here. But Woody Allen brought a lawsuit against Amazon. Remember, Woody Allen had issues with allegations. Again, allegations doesn't mean they're true, about sexual misconduct and stuff like that with certain individuals. I'm not going to bring that up, but he sued Amazon because once that occurred, Amazon just said, okay, we're not going to do some of these shows with you. Yet Amazon knew about these. He's claiming knew about these claimed allegations, and they still went forward with it. But then they backed out. The Me Too movement got on it. It was just kind of during that time period. So the case settled. And he asked for $68 million, and then it settled for an undisclosed amount. Denise, you were going to say something?
Yeah, he had a good point, because when he came to an agreement with Amazon, he had already been divorced from Mia Farrow, and all of these allegations came out of that divorce. So Amazon already knew about those allegations, and still they had a contract. Right. And then what happened is that Ronan Farrow brought this up again, and the accuser took out an op-ed, I think, in a newspaper, and then that's when Amazon
said, "Whoops, we don't want to deal with this."
Yeah, they backed out.
Well, good. So well, it's settled.
And Woody's back in town.
Yeah, back in town. Okay, so we've been skipping on case or no case a little bit here. We always do it at the very beginning, but I think we've mixed it up just to have a little bit different mix. But let's roll our final for this day, Saturday. What is the date? November 16th. Case or no case?
Now it's time to play Case or No Case.
Yay! Georgia Cano is a toon, an animator, starting her career on the ground floor of computer animation visual effects in the movies in the mid-1980s. Always loved the work of people who brought you never-before-seen imagery for Star Wars, Jurassic Park, Toy Story, Shrek, Polar Express, Avatar. But she said these toon people have been taken advantage of financially for decades because she claims Disney, Sony, and 6 other Hollywood studios violated antitrust laws by conspiring to press the wages of animators by agreeing to never poach from another company and therefore not allowing people to cut their own deal. It wants to become a commodity in Hollywood. You know, your wages should go up. She said this would never happen. She realized her wages were being suppressed sideways, mobility to competitors were limited, so she decided to do something, and she sought a lawyer. And so I ask you, Mr. Cunin, it's your turn, and you were in the lead. Case or no case?
Okay, I'm going to say that this is a case. And when it comes to, how should I put this, non-competition clauses and whatnot, things vary state by state, but you said Hollywood, which I know is in California the last time I checked my geography.
Not the Florida Hollywood.
Not the Florida Hollywood, but this is Hollywood in California, and I know that Business and Professions Code Section 16600 in the California codes basically invalidates non-compete clauses in California. So if you go to work for somebody and they say, if you work for us, you can't compete with somebody else here. Sorry, 16600 says that is illegal. Or not valid, not a valid contract, not a valid provision, and to the extent that was being used or anything close to it by folks in Hollywood to keep animators from moving to other locations, it would be a violation. She has a case, so I'm going to say it is a case. They file a lawsuit. Difficult thing's going to be proving it. It's hard to prove what people claim to do behind the scenes, but she prevails. I'm going to say she wins.
Okay, I will give you a bonus point. If you think it's a case, if you think it's a case and you claim plaintiff prevails, if you can give me an amount within 10%, I'll give you an extra point.
Okay. Can I wait for everybody else to answer while I think about that?
You can do that, and we'll do amount when we're done. Ms. Dirks, what say you, case or no case?
What year was this?
She started in the 1980s, mid-1980s, she said. That's when she started her career.
Okay. So you're exactly right on the law. And one of the things that they said,
Could we get that clip
the legislatures had said when they enacted that law was that it is akin to slavery. They actually made a mention that it was akin to slavery.
Wow. Involuntary servitude,
exactly. Very good. So I think this is a real case. I do think that the animators probably had some piece of helping this law become in effect. And I'm going to say that it's a case and she prevails.
Okay. Mr. Penney, what say you? Case or no case? You've got two people who say it is.
I've done a horrible job today. I've lost every single time. So I'm just playing the odds. I'm going to say no case. Everything they say is absolutely correct. But I just have to go for the odds and go for the points. So I'm going to say no case.
All right.
It's all strategery.
Well, you will never get the extra point.
Oh, wait a minute. Let me back up.
No, I said if.
I don't agree with that. That's true. You gave it away. Yes, it's a case. I agree with them. I'm changing. Your Honor, I'm changing.
Here's what I said. I said, if it is in fact a case, then give me within 10% of the amount they want.
It's a case, and I'll give you the number.
Okay, go ahead.
And I'm going with them because now that tipped it off, huh? That's like saying I swung. Wait a minute. It was when I swung the bat. I only swung it halfway, Todd.
Okay.
So
okay.
It was. I didn't swing all the way through.
I want to change my answer.
So
no case.
Case. And how much does she win?
Yeah.
I'm going to say $100,000.
Okay. Now, for Todd, for one extra point within 10%, what was the amount of settlement of this particular case that you say was a case?
Well, I could see you doing the whole bonus point as a red herring, and it's still a no case. But I've already said my answer, and I'm going to say she wins $2.5 million. I'm
going to be ticked off if Denise, you're smart.
I'm going to change it. No case.
You're going to say no
I
case.
am.
Wait,
I am.
Can you change it midway after you hear everybody else's answer?
I guess
Sure.
Okay.
You
all
can be
right.
a contrarian in this case.
Okay.
I welcome
All right, here we go.
I don't know. I think it's a case now, given how quickly he's allowing you to do
I
this.
welcome contrary opinions, especially when I ask the question. All of those who say it is a case, raise your hand. Fred and Todd.
Yes. Oh, I'm so glad I changed.
To those of you who said that this turned into a class action suit that ended up having a value of $168 million.
How much did you say?
For all of the
2.5.
animators, so none of you were close on the amount.
Yeah.
But nonetheless, you were correct. It was a case. Plaintiff and it turned into a class. They all prevailed, and the law was changed because of what she...
$168 million.
It's a big deal.
Wow.
The legal firm that represented them is going, we in the money.
Cha-ching.
Exactly.
I thought you were going to stump us 3 times. I just did.
I came close.
Wow, I got a couple points there. So Todd and I each got 2.
Yep, that's right.
And Denise, you got sorry.
I got goose egg.
Okay,
but I'm still in second place.
Okay.
You're in last.
I know, I'm a loser. All right, we're gonna try to get through this. Denise, you called me a loser. Talk about this United Airlines pilot award of $300,000 after wrongful. Apparently, they were trying to claim there's an indecent exposure issue here. Is that correct? What happened,
yeah.
Denise? What happened? I don't. You know, because this is right up your alley.
This is an interesting story too.
And we'll tell you about Denise's Oregon rooftop issue later. That one creeped back up. That was from 2 years ago. We talked about that.
Oh my gosh! Yes, I thought you wouldn't remember that.
Oh, I remember. We've already interviewed all your old friends with you that were
Todd,
with
you have to take over on this one. I'm sorry.
Well, so essentially, the claim was that this pilot. The claim was dated September 20th, 2018, and Denver International Airport employees claimed that they could see this pilot in front of his 10th floor window of his hotel, nude and in an act that was suggestive of indecent exposure. And let's see, he was arrested, charged with indecent exposure, pled not guilty, arguing that being nude in your hotel room is not a crime and that he was not aware that anyone could see inside. Because if you're on the 10th floor, I mean, is it reasonable that anyone could see? And
someone was looking.
Yeah, but the judge in the case dropped the charges. Now, he sued because of this, because he was terminated. Look, this incident caused him a lot of problems. Every time he'd come back into the country, he'd be stopped by Homeland Security to answer to what is happening and what has happened here. And
United Airlines suspended him for 6 months.
That's right. And he was awarded $300,000.
Who did he sue?
For the wrongful bust, I believe.
Oh, the city of Denver.
The city of Denver.
Oh my gosh.
So
Wow. Good for him. Good for him. Anyone that's standing, taking their clothes off on the 10th floor of a hotel room, I think everybody in this room and in Cal's room are guilty.
Well, yeah.
Everybody.
Good for him, except for his exhibitionist tendencies.
Well, whatever that is, the fact is you got your window open, 10th floor, someone's looking in.
Right.
That's their problem, not mine.
And the hotel let him go in without a warrant, so multiple violations of the Constitution, which don't, in and of themselves, result in monetary value.
We'll be back.
All advertising for legal services on Radio Law Talk is strictly for the state or states in which the advertiser is licensed. For more information, go to radiolawtalk.com.
Warning, don't let your business get left behind in what is likely to be the biggest economic boom in recent history. If you need to build for your business to grow, call General Steel today for a pre-engineered steel building designed for your needs. No wasted space. Steel prices are expected to rise, but you can still lock in your price on a General Steel building. And you can still save as much as half the cost and time of conventional construction. As much as half. But you must call now. If you need a church building, office, warehouse, warehouse, manufacturing space, retail space, or more. Call General Steel today. You can still get the General's 50-year structural warranty and General Steel quality, all at a price you can afford. So don't let rising steel prices put your project out of reach and stop you from making your company great.
800-617-9312. 800-617-9312. 800-617-9312. That's 800-617-9312.
This is Denise Dirks. We can represent clients in divorce, legal separation, child and spousal support, custody, termination of parental rights, step-parent adoptions, guardianships, and even conservatorship matters. Call 1-877-886-7186 for a consultation.
The law offices of Denise L. Dirks provide family law services in Northern California. When the law affects your family, call 877-886-7186. The family of attorneys at Denise L. Dirks is here to help.
Jason Ross back here with Fred Penney, managing attorney from Penney & Associates Injury Lawyers. Now, Fred, what type of cases are you dealing with now, and what sets you apart?
Jason, we help people with all types of personal injury cases. We're former insurance company trial lawyers. We understand the other side, which gives us a distinct advantage over our competition. Remember, we don't get paid unless we win.
That's Penney & Associates Injury Lawyers with locations throughout California. For a free consultation, go to pennylawyers.com or give them a call, 1-800-616-4LAW. That's PENNEY lawyers.com.
The cost of getting rid of garbage is high, and recycling products is lucrative. If you're a business or know of a business that needs an individual compactor or baler, call Northwest Compacting at 888-201-0911. If you already have an industrial compactor, baler, or shredder and need service, don't forget to call Northwest Compacting at 888-201-0911. Northwest Compacting, your full-service industrial compacting and baling company. Read more about them at northwestcompacting.com.
Many women have so many clothes in the closet, but then we go to get dressed and find we have nothing to wear. We've all been there. We all want to be comfortable and fashionable at the same time, and it's difficult to find clothing that makes that task effortless. But at Letty & Company, you can find trendy, comfortable clothing that is affordable, things you'll want to wear every day. Shop with a purpose, online with free shipping. Just go to LETTYandcompany.com. Letty & Company.
If you're one of those independent people who wants your own business and you love food service, we just might have a great opportunity for you. Iceberg Drive-Ins. Iceberg is famous for its thick shakes and delicious food. We lend you our supply chain and expertise, and you can potentially have a thriving, successful, fun business that your customers will love. Iceberg Drive-Ins has some prime areas available right now, so if you're interested, get in touch with us right away. Go to icebergdrivein.com and click on the Contact Us button. Iceberg Drive-In, ready to grow with you.
I am Cameron Levitt, Chief Operating Officer of Concussion Medical Clinic. California's first concussion medical clinic is now open. As concussions increase each year, there has never been a greater need for concussion specialists. Our physicians at Concussion Medical Clinic are board certified in pediatric neurology and sports medicine and have partnered with universities, hospitals, and rehab clinics to expedite the recovery process. Simply put, we are elevating the standard of care. When you need an expert concussion opinion or concussion care, visit concussionmedicalclinic.com to schedule your appointment.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penney.
There's some interesting things that happen in Louisiana, I believe, Denise, that, again, is the dog whistle one. Tell us a little bit about what this judge offered a rapist.
Yeah, and the rapist is convicted.
Right.
Okay, so what the judge does in sentencing is he says to the convicted rapist, if your victim will agree to accept $150,000 from you, then I will agree to reduce your sentence.
Hey, guess what, though? Think about it now. I'm going to jump on the judge's side. All right.
Okay.
Think about this. Okay, that sounds horrible.
It almost sounds like a payoff.
But listen to this. All right, I'm the judge. I'm just going to put myself in the judge's. I will reduce your sentence if you agree to pay this victim $150,000. Your Honor, I agree. I will pay $150,000 out of my account. This guy apparently probably has some money that was convicted. Let's assume he does or she does. I was a he, if I remember. All right. So it says that the typical conviction would be 12 years in prison. because he ordered him to serve 12 years in prison. Got it? Okay, I'm setting the scenario up. Your Honor, sir, if you want to pay $150,000 to this victim out of your whatever your account is, because don't forget there's ways to hide it and get rid of it. She's got to go through a lawsuit. That's a lot of, and I will reduce your sentence. Your Honor, I agree. I will pay him $150,000 in order to have my sentence. I agree to pay her $150,000 to lower the sentence. And then if she agreed, it would be her consent. If she agreed, the judge goes, I move you serve 11 years, 11 months.
You know what? No, you know what? This is
sets a precedent. I agree.
The victim was 15 years old at the time.
At the time.
I am sorry.
Yeah.
And that to me is the judge setting the value of what happened to this victim when she was 15 years old. And no, $150,000 is never going to make somebody whole from being raped. I'm sorry.
And I agree with you 100% on that. But just think about it. Now, this really sounds stupid. I know I'm jumping on the side you shouldn't jump on, but think logically about it. He didn't say how much he was going to reduce it. But Denise, if you're she was 31 years old at the time of this conviction, correct?
Yes.
And maybe she's struggling a little bit, and to give her $150,000 that she couldn't get anyway, and the judge again, maybe it's I'll give you 11 years, 11 months, 28 days. That's a way to slap him in the face. Slap him in the face.
Yeah, slap him with $1 million. Don't slap him with 150.
Maybe you're right.
That's too low.
I was going to say $150,000 put in an account for a 15-year-old in a trust that she can't get to and earns interest. She could be literally financially set for.
She's 31 years old now.
Oh, I thought she was 31
She was 15
now
at the time.
Okay, so never mind. Never mind.
So by the way,
$1.5 million.
The victim did not agree to that. She said that no money is going to provide me with my 16 years of suffering back.
Good for her. Way to go. You bet.
Couple of issues that I have with this. First of all, this was in Louisiana. They have the Napoleonic Code. It's different there than it is in any other state that follows pretty much common law.
And what's the Napoleonic Code? Because I think we should say that it's from France.
It is. I'm not aware of Napoleon, Sweden. But, so the Napoleonic Code comes from France. And anybody who's heard of the Louisiana Purchase, we actually bought Louisiana from France a long time ago. But this is the point I want to make. There is an ethical rule in California, a lot of other states have this, that says that you cannot use a criminal action or a threat of a criminal action to settle a civil case. So in a criminal action, you can't say, well, if as a prosecutor, if you do this and this is settled, the civil case and agree to pay all this, I'll go light on you and make you a better offer as a prosecutor. It sounds like the judge may have done that. And the reason I say that is for this reason. A judge can always order restitution in a case, right? And so somebody might say, well, what if the $150,000 was restitution? Judicial restitution is to compensate somebody for actual damages. So unless she had $150,000 in medical bills that she can show, somebody's got a car that's ruined and they show the value of the car, that's what restitution can be ordered for. They cannot order, and judges do not order restitution to cover pain and suffering, things that would be punitive damages in a civil case. And I don't see a restitution claim ever submitted in this case for $150,000 from the victim. Given the fact that she rejected the offer, would tend to indicate that there was no restitution claim. A judge is entitled, if a defendant wants to pay off a legitimate restitution claim, to reduce the sentence in exchange for paying the entire restitution up front as opposed to nickel and diming the victim. That did not happen here. This one appears to solely be an offer by the judge.
He pulled the amount out of his
and an offer that would arguably satisfy some sort of yet-to-be-filed civil claim. It was inappropriate, and kudos to the victim for turning it down.
Yeah, I agree. And the judge himself said this will not be considered an extortionary offer. So even he felt that he had to say that to protect himself, because it does almost sound like extortion. It sounds like, hey, I'm going to penalize you really badly unless you do this.
So he says, I'm going to extort you, but this is not an extortionary offer.
Yes, because saying it's not that always works. It's like employment. So you're not an independent contractor. You're not an employee. You're an independent contractor, even though I'm going to treat you like an employee.
But remember the Bill Cosby case.
Yes.
And Bill Cosby got a non-prosecution agreement because he allowed for a civil suit to go and to cooperate and do a deposition in the civil suit. So the prosecutor then said, I'm not going to prosecute you. What happens?
A new prosecutor
comes in and uses the deposition in the civil suit against Bill Cosby and convicts him, and he is in prison today.
Still.
And the problem with the judge in this case was the chief concern he appeared to have was whether or not this could be viewed as extortion. And he completely overlooked the fact that it violated the ethical norm of using a criminal proceeding to settle a civil case. And that's a completely different analysis. It's not extortion, still improper.
I just thought it was interesting. Yeah. I think these things are fascinating. Let's talk really quickly about victims of the big, there's a Northern California food festival called the Garlic Festival. It attracts over 100,000 people a year. It's huge, this Garlic Festival. So a crazy gunman comes in and kills 3 people and wounds 13. He cut through the chain link fence, came in and went on a rampage. So now guess what? It's a shocker, but there's a lawsuit now against the Garlic Festival saying the following. Number 1, they had outdated contract with the security provider. 2, they did not include modern day risk to large public events or plan for worst case scenarios. And 3, they were grossly deficient with their security and the fencing because it was flimsy. And finally, they didn't have enough trained security
officers. Is flimsy a legal term?
I don't know, but I think about the big, huge bolt cutters they have. I don't know if you can even make a fence, strong enough that a bolt cutter is going to get through, especially unless you don't do chain link, you do one like up on the border, a border wall.
But a determined bad guy seems to be able to do what a determined bad guy wants to do.
Well, what's the interesting thing here in lawsuits now, the lawsuits from these mass shootings, is what is the security level that now these big festivals and events have to go through? That's the question. When is there enough security? And what do you have to do in order to be secure enough from people coming in and shooting people up? I don't know. I mean, how do you stop someone from jumping a fence or cutting through a fence?
Is the judge going to be able to say, well, that's secure enough? I mean, who's going to set the standard?
Well, there's standards probably. You're going to have experts. I'll tell you, we call it the dueling experts. They're going to have experts in security that are going to determine what you should or shouldn't do, and then that's what they do. It's dueling experts. We're going to do our famous quick takes, right, Cal?
We are. Fred, I'm going to ask you if you have yours ready.
I do.
Your quick take, Mr. Penney, is...
What happens when your comfort chickens becomes your comfort meal?
On the heels of that, mine is... Wilbur discusses his codependent relationship with the chickens in the hen house. This is the log line from the pilot episode of the Mr. Ed reboot.
And Ms. Dirks, your quick take is...
Remember, just a tip. You don't need a surgeon to cut on your tummy to get circumcised.
Wow, we're ending with that one. Thanks for joining us at Radio Law Talk. Come join us next week. Those of you in Eastern Kentucky that join us for the first time, please come back. It's usually not this bad. Cal, thank you. We'll be back next week, Pacific time, 9 to noon.
Thanks for listening to Radio Law Talk. See you next time.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated.